The last really important thing, and this really doesn't fall under the memo so much, but always keep in mind that when the person is working at a client site, the LCA has to be for that location, and you must be paying the proper wage for that location. With the new LCAs that were instituted last summer through iCert, you do have to list the entire complete client address on the LCA, not just the city anymore in the state. So make sure that you have the proper LCA in place before the employee starts working there, and that you're paying the proper wage as soon as the worker switches locations. So I mentioned that I would talk about software a little bit. The memo makes a big deal about proprietary software. In the first example, where they said the right to control does exist, the USCIS basically stated that the employer is more of a software development company, and they're using that in-house proprietary software to develop the client's project. Now, obviously in the consulting business that's probably not going to be the case, but there are other ways you can use proprietary information and make your employee use that proprietary information to show that you are controlling the employee and have the proper employer-employee relationship. So besides having software, you obviously have different procedures and processes for how you want the work to be carried out and how you want to interact with your employee. So if you don't already have something set up, you need to institute a training program for all of your company procedures, processes, how you want your employee to act when they're at the client site, and create a training manual and make sure as soon as the employee starts working for your company, they go through an extensive and rigorous training program on your proprietary processes and procedures. Once the employee is placed at the client site, make sure that the employee is using your processes and procedures to carry out the work, rather than using the client's. Now, I know there are certain things that the employee has to do based on the client instructions, but there are certainly things that you can institute yourself that probably won't cause any problems for the client, but still show that you're able to control your employee when they are at the client site. As far as software is concerned, I mentioned that if you are going to purchase laptops for your employees, you should load the software on there that the employee will need at the client site. Now, one good thing about the IT industry and the consulting industry is that you all know how to develop software. So you may want to consider developing software that will allow you to interact with your employee when they're at the client site. For example, the employee has to do their weekly reports in your software, your proprietary software that you developed. They have to keep their timesheets in your proprietary software. And every week, your manager logs into that software and has to approve what the employee has done for that week, and it approves the timesheets. Therefore, and you also include a print capability so that when you do get your request for evidence, it will be easy for you to respond because you can print out a report of all of the weekly updates you've received from your employee while they were at that client site. Now, obviously, the employee is likely to have signed a confidentiality agreement, so I'm not stating that the employee has to provide all the minute details of the project, but they can at least give an overview of what it is they've worked on that week, who they've met with when they're at the client site, and any other details such as that. And again, they can have the timesheets put into that program as well. So that's something you may want to consider. It's also important to point out, again, obviously in the consulting industry, there are going to be times when your employees are between projects. We highly recommend that when they are between projects, they come to your place of business during normal business hours, Monday through Friday. During that time, they can receive additional training, they can work on your proprietary software, work on any in-house projects, or support other employees who may be working off-site, and make sure during that time that they are paid the proper wage. There's no benching allowed. With all that said, I know it sounds like I'm asking a lot of you, but it really is important for you to institute as many of these things as is feasible, so that when you do get your request for evidence, you will be armed with the proper documents to respond to it and be successful. The good news is that the determination of the employer-employee relationship is based on the totality of the circumstances. There's not just one factor that controls. So, for example, I gave you a list of the many things that USCIS will ask for in their request for evidence and all of the factors involved in their determination. So if you are missing one factor, that is not the end of the world. You can provide more information showing that you do comply with all of the other factors, and therefore, based on the totality of the circumstances, an employer-employee relationship does exist and your company is eligible to file that H-1B petition. Also, one of the arguments that could be made in response to the request for evidence is that USCIS cannot make a law through the memo, or at least can't change the law so drastically through just a memo. It is in violation of the Administrative Procedure Act, which requires that any new regulations be posted for a certain period to allow the public to comment on them. Once the USCIS goes through all the comments, then they can post the final rule and discussing each of the comments they received and why they made the decisions they made. This memo did not go through that process, and some may consider that this is an actual change in the regulations rather than just an interpretation of the current law. And so that's an additional argument that can be made, that this memo maybe not have the strength that USCIS would like it to. And finally, there are a lot of tests out there for how to determine the employer-employee relationship. The basic test is the common law, which was created by the courts over time, which basically says whoever can hire, fire, pay, and has the ability to control or supervise. Obviously, USCIS has taken it much further than that and gone much more restrictive. Even the IRS has a much less restrictive test for that. Basically, anyone who performs services for you is your employee if you can control what will be done and how it will be done. That's it. That's the end of the test. And so they look at the entire employer-employee relationship, and if the employer can control how the work is done, what will be done, and when it's done, you're an employer and they're your employee for tax purposes. That similar test should be followed by USCIS, and so that's one additional argument that could be made. Thank you for listening to my video presentation today. Again, my name is Emily Newman, immigration attorney with Reddy & Newman PC. We're located in Houston, Texas. We also have an office in Dallas, Texas. If you have any questions, please feel free to contact us at 713-953-7787. You can also find us on LinkedIn, on Facebook, and on Twitter.